The final segment from the Ethics Committee's live webinar on lawyers' business relationships explores the co-counsel relationship. I'm Nick Critelli, Chair of the Iowa State Bar Association's Ethics Committee, and this segment explores Ethics Opinion 1305. Co-counsel relationships are extremely beneficial to the client. It brings together two or more lawyers from differing disciplines to form a legal team for the client, a legal dream team, so to speak. But what happens if the dream turns out to be a nightmare? The co-counsel relationship. Co-counsel relationships can be very comforting to both the co-counsel. We do a lot of this with firms, and it's always a pleasure to have that lawyer who's that client's trusted advisor being kind of the lead with respect to the case. And hopefully it's a benefit to them too. So they are very comforting when it works well. There are some situations when they don't work well, and we'll cover that. So co-counsel is 1305. Okay, once again, going back to our clouds, it comes with all aspects of the relationship: confidentiality, conflicts, consent, supervision, and compensation. Okay, confidentiality and conflicts, everybody understands. That's pretty basic. Okay, consent and compensation, kind of everybody understands that. Do you have to get client's consent to get a co-counsel? You betcha. Okay, same way with compensation. But what about supervision? I mean, what happens here? Am I my brother's or sister's keeper? Well, let's take a look at what the duties are. Okay, what are the duties? Well, there's a duty of mutual cooperation. In other words, we got to get along. Okay, one's not superior or inferior to the other. We are co-counsel. Okay, it's a joint venture, unless there's a limitation. Okay, I told you before, under 32 1.2c, I can limit the scope of my representation. I'm going to do these things. That's what I'm going to do on my part of the relationship. You're going to do the other things. And then, in that situation, you're responsible for your half, I'm responsible for my or third or whatever it is. Okay, but you can divide this up. Okay, and when you divide it up, then you're only responsible for that portion that deals with you, obviously. It's important that you do that, because if you don't do that, then you're deemed to be involved in all aspects. Now, the last part, am I a snitch? Okay, the snitch rule. And that is, if I see my co-counsel doing something that's just unethical or wrong or committing malpractice, just turn them in. I have a duty, an obligation to snitch, to rat them out. Put in pretty harsh terms, but the bottom line is, okay, you do have an independent duty which overrides the obligation to, your independent duty overrides the obligation to the client. That's not that bad. Independent overriding obligation to the client to be forthright and truthful with the client. So, duty of cooperation, but first and foremost, you individually have your duties to your client. Okay? And yeah, that could include the duty to, to say, look, we got a problem here. I don't agree with my co-counsel on this, that, or the other thing after you tried to work it out. Fee division. Okay, Iowa Rule 32 1.5 says, yes, you can divide the fees. A division of fee between lawyer and lawyers, okay, number one, I'll get my highlighter out here again, okay, who are not in the same firm may be made only, and this is out of the rules, only if it's in proportion to the services performed by each lawyer. Okay, that's so you keep track of your hours, I'll keep track of mine, and we'll divide the fee accordingly. Or, there's an or in the rule, each lawyer assumes joint responsibility for the representation. So if I'm on this thing jointly, that's 50-50, then we go that route. So basically, the division of the fees depends upon how you divide it, provided the client approves of it. The client has to approve this in writing, including the fee. One more time. The client has to approve this in writing, including the fee. And, of course, ultimately, as with all attorney fees, the fees must must be reasonable overall. So these are the two takeaways here. In writing, folks, I see a lot of relationships where this does not include, where it's not in writing. Watch that rule. Here's a classic agreement. This is the one of those that we had with Marty Fisher. He's the instructing counsel. We'll follow his leads. We're going to provide instruction. We'll take instructions from him and his law firm. This is the statement of work. We're going to provide the following deliverables: due diligence, decision-making, strategic analysis, pleading, computer-assisted litigation, expert witnesses, law briefs, hearings and trials, negotiations. So we identify those different things that we're going to provide so that we know what our role is, okay, to be able to provide that for them. Attorney fees. In this situation, I think we were splitting it equally because we both had an equal obligation on the case. It's set out in writing so that there's no misunderstanding with respect. Well, there you have it. We've explored 5 lawyer-business relationships. Now, I hope you found this series beneficial. I want to end by thanking the members of my ethics committee for their hard work and dedication. A lot of work went into building these opinions. If you have any questions or comments, please feel free to contact me at nick@critellilaw.com, nick@critellilaw.com. Thank you very much.